Greetings and welcome to Stand with Pride, a weekly recap of the news. We open today's show with this commentary from Paul Blumenthal. The Supreme Court is illegitimate. Whatever meager shred of legitimacy the U.S. Supreme Court had went up in flames with its shadow docket decision on Tuesday, allowing Alabama to move forward with a racially discriminatory congressional map, with no time for election administrators to prepare. The brief, unsigned decision to allow Alabama to implement a never-before-used congressional map, repeatedly found to be racially discriminatory by a district court panel and a previous Supreme Court ruling, is so shoddy and partisan that it is hard to take the court's conservative supermajority seriously anymore. In April, the Supreme Court ruled in Louisiana v. Calais that to challenge a racial vote dilution under the Voting Rights Act, plaintiffs must prove intentional racial discrimination rather than merely discriminatory effects. At the same time, it allowed legislators to immunize themselves by claiming partisanship as a pretext for eliminating majority-minority districts. An easy task in southern states with high levels of racial polarization. Alabama Republicans seized on this, not to further bury the Voting Rights Act, but to defang the Reconstruction Amendments that gave the law its constitutional life. The resulting decision is as monumental as it is brief, and it reveals a court untethered from a semblance of duty to explain itself. The case Allen v. Milligan originated in 2021 when Alabama drew congressional district lines with just one Black Opportunity District, as it has since the 1990s. In a lawsuit, Black Alabamians alleged that the Voting Rights Act required the state to draw an additional Black Opportunity District and that the redistricting process was tainted by intentional racial discrimination. And they won before a district court panel in 2022 and again at the Supreme Court in 2023. A curious thing happened next. Alabama simply refused to abide by the Supreme Court's decision and draw district lines with a second Black Opportunity District. The same district court panel found this map to be the product of intentional racial discrimination because of both the manner in which the legislature drew the map, including discussing creating communities for those with European heritage, and the placement of Black voters, and because Alabama refused to draw a second Black Opportunity District after being explicitly ordered to do so. This led the district court panel to impose its own map for the 2024 election. But then came Calais. While Calais claims not to undo the Voting Rights Act, it does just that by making it all but impossible to win a Voting Rights Act case regarding redistricting. In a state like Alabama, where Black voters are overwhelmingly Democrats, and white voters are overwhelmingly Republicans, all Republicans need to do is claim they are diluting Black voters because they are Democrats. The result has been a mad dash reminiscent of the onset of Jim Crow by southern states controlled by white Republicans to eliminate congressional and state legislative seats held by Black Democrats. But the decision in Calais also stated that it said nothing about challenges of racial discrimination brought under the 14th Amendment, as the Black Alabamians had done, and the district court panel had ruled had happened in Allen v. Milligan. It also explicitly stated that Calais did not overturn the decision in Allen. "We have not overruled Allen," Justice Samuel Alito wrote for the majority. Alabama Republicans responded by asking the Supreme Court to lift the district court panel's injunction imposing the map with 2 black opportunity districts, and in the meantime passed a law to postpone its congressional primaries to impose the racially discriminatory map in case this happened. The Supreme Court approved Alabama's request and ordered the panel to lift the injunction and reconsider the case in light of Calais, which the panel did, finding that the map was still racially discriminatory, even under Calais. Alabama then petitioned the Supreme Court to overrule the panel, and the court did. Despite the district court panel finding that Alabama had met the high bar prescribed by Calais and engaged in intentional racial discrimination, and basing its ruling on the 14th Amendment as well as the Voting Rights Act, the Supreme Court's conservatives expanded on Calais. It took Calais' requirement that partisanship trump race from Voting Rights Act racial vote dilution cases and broadened it to 14th Amendment racial discriminations cases. And it raised the bar for proving intentional discrimination even further, requiring courts to presume legislative good faith whenever judging the legislature's actions. This makes it truly impossible to challenge a discriminatory map under the Voting Rights Act or the 14th Amendment, even in cases where discriminatory intent was clear, as it was here. And so Calais, in fact, did overturn Allen, even though Alito and the 5 Republican-appointed justices who joined his opinion claimed it did not. In more ways than this decision is wholly disingenuous. In election-related cases, the court frequently invokes the so-called Purcell principle, which states that courts cannot change election laws or rules too close to an election, lest they disturb the electoral process and confuse voters. How soon is too soon? It's up to the justices. Which elections does this apply to? Again, that's up to the justices. And how does this shake out? In this very case of Allen v. Milligan, the court invoked the Purcell principle in 2022 to block the district court panel's decision requiring a second black opportunity district because the election was 7 weeks away. Even heroic efforts likely would not be enough to avoid chaos and confusion, Kavanaugh and Alito wrote in concurring with this decision. This allowed the state to hold its 2022 election under a map that provided it with an additional Republican congressman. Now the justices see no problem with lifting the injunction on the district court's map imposed under this Supreme Court's orders, in the middle of a primary election, with voters already having begun casting mail ballots 5 weeks ago. And in reversing the district court's decision on Tuesday, the court gives state election administrators mere days, if that, to reassign millions of voters into new congressional district lines, something that Alabama's director of elections testified usually takes 3 to 4 months to complete. This apparently does not take heroic efforts to avoid chaos and confusion. In dissent, Justice Sonia Sotomayor joined the other 2 liberal justices, slammed the court and Alabama for manipulating the Purcell principle. What was previously impossible to achieve in 4 months is suddenly possible to achieve in less than 1 week, as concerns about the administrative burdens associated with the last-minute reassignment of hundreds of thousands of voters to new districts have apparently just melted away, Sotomayor wrote. The Republican-appointed justices come up with another new rule to get around their obvious incoherence, one that is a non-subtle hint to Republican-led legislatures. While federal courts should not impose changes close to an election, states are free to decide for themselves whether last-minute changes to an election are in their best interests, the unsigned Tuesday decision states. What the court is saying is that because the Alabama legislature passed a law in the middle of an ongoing election to redraw its congressional districts after years of defying the entire federal judiciary, the Purcell principle does not apply. This decision invites total chaos upon elections, as state lawmakers now know they can tinker with elections up to and beyond the last minute with no possible remedy. The justices, they do not bother to consider that their action here as a federal court is responsible for the ensuing chaos and confusion. The Supreme Court could not have lifted the panel's injunction until after the election under the valid belief it would cause the chaos and confusion they are so concerned about. This kind of Calvin ball jurisprudence, as Justice Ketanji Brown Jackson called it, has been a hallmark of the Roberts Court's increasingly partisan decision-making in recent years. In her dissent in a case involving the Trump administration's cancellation of research grants, Jackson wrote, Calvin ball has only one rule. There are no fixed rules. We seem to have two. That one, and this administration always wins. On Tuesday, the Roberts Courts proclaimed another. Republicans always win. And they did so by nullifying the hard-won successes of the civil rights movement. For anyone who still had doubts about the court's ongoing illegitimate power grab, this decision should make it clear where this court stands and where it is headed. This concludes Paul Blumenthal's commentary. If you are watching the video version on YouTube, please leave a comment to let us know if you agree or disagree with his opinion. We're going to take a brief break, and we'll be right back after these messages.